Good day, everyone. Good evening. How are we doing this very, very fantastic Saturday again? You're very, very much welcome to the fifth edition of the Startup Compliance series. I am very, 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 very excited to have everyone here. So, we're just going to use this opportunity to make 1 minute for those who are joining us. I know that today is a very interesting day right now in Nigeria. So I know with all the events that have happened today, maybe some of us are feeling kind of bluesy, or we're just trying to rest from maybe some of the stress that we had today. So we understand. And for you to take the time out to actually be a part of this, I want to say a very big thank you for everyone joining in. My name is Rosemond Phil-Othihiwa, and I am privileged to be the host of the Startup Compliance series. The Startup Compliance series basically is an online event where we speak to different areas that the startup ecosystem literally runs through. So we are very, very particular about bridging the knowledge gap for startups, for business owners, and for, of course, practitioners, whether in finance, in law, or in different areas, so that they are able to understand what is required. So, as you're joining this stream, please put a comment in the comment section. Tell us your name, tell us where you're from, tell us what you do if possible, and what you're looking out for towards, getting to know, getting to enjoy, or getting to learn from this session. So, like I said earlier, this is the fifth edition of the series. We meet every month, at least twice. And so please feel free to, network with someone. This is going to be an interesting conversation. As we all know, the topic of today is data policy, privacy, and compliance for startups. And my guest is already here in the background. It's waiting to join us. So I want you to put that comment wherever you are in the comment section and just let us know where you are watching from, where you're viewing from. I can see more people joining in. Definitely, as you put in your comments, I'll definitely be able to see. So once again, I want to welcome you to another session. This is going to run for an hour, and then of course there'll be 30 minutes for questions. So before I bring on my guest, like I mentioned earlier, my name is Rosemond Phil-Othihiwa, and I am privileged to be the host for this series. And we're definitely going to have an interesting time. One of the core things that I observed in my interrelation, my work with or my work for a lot of small businesses, startups, and even SMEs in this likes, I realized that there is a whole lot of information that is not known, and there's a lot of guesswork going on, especially in the regulatory or compliance space. So one of the key critical things that this series loves or has gotten the vision to accomplish basically is to close those knowledge gaps, right? So I'm not going to talk too much. Yes, I see your comments. Keep it coming. Thank you for joining in. I see that our viewers have increased. You're welcome. You're welcome. Please, I'm still looking out for names, right? I'm still looking out for names in the comment section. So please share with us your name, where you're joining us from, and then, of course, definitely what you're looking forward towards learning in this session. And please share this link with someone who needs to hear what we're talking about, right? So thank you. Ridwan Badmus says he's amazing to be here. He's commenting from Lagos, Nigeria. Thank you, Ridwan, for being here. It's such a pleasure. Thank you so, so much. And we're very, very grateful to have you here. So, very, very quickly, I would be introducing my guest. I really, really wish it was like a physical event where I could just, say make welcome, and then, you can do the whole physical clap. But wherever we are, let's put our virtual claps on. Yes, we are definitely on YouTube and on LinkedIn. So yes, we see Lollywood. Yes, definitely commenting. Yeah, hi, how are you doing? Yes, nice to meet you, Oladayo Akimoku. It's such a pleasure. Thank you very much. Thank you, thank you, thank you, thank you. So without further ado, I'm going to introduce our guest. And I want to make welcome Samuel Ungu, who is definitely going to be taking us on a very interesting ride. So please make welcome. If you can put a comment box, or you can put in the comment box, just say you're welcome, Samuel. Samuel, you're with us right now. So please feel free to unmute yourself, and it'd be great to hear you while I introduce him. Definitely, why shouldn't I? But before I introduce, before of course he speaks, I'm going to be reading his profile, which is definitely being shared at the moment. Right. So, like we all know, our topic is policy, privacy, and compliance for startups. Samuel is an associate at Alliance Law Firm, where he provides cutting edge legal services to clients in data protection, intellectual property, financial technology, and corporate commercial law. He possesses deep knowledge and understanding of privacy and data protection in the landscape. He's a certified information privacy professional and has advised and implemented data protection compliance for several clients, including startups. He's a co-founder of Privacy Hub Africa, Association of Privacy Lawyers in Africa. He's a member of stakeholders in Blockchain Association of Nigeria, Young Lawyers Association, and the Nigerian Bar Association. He's well published and a regular invitee to speak on data protection sharing matters. And so, without further ado, please make welcome Samuel. Samuel, it's such a pleasure. It's nice to meet you. It's nice to have you here. How are you doing?
Thank you so much for bringing me here to speak. I'm doing fine, and
How
I
is
know
the
you're doing
Sat?
fine.
Definitely. How is the
Yeah,
Saturday going on in your end? I hope all is peaceful over there.
yeah, we believe, we want to believe that everything is fine.
Yeah.
Yes,
Why? What can we do really? Okay. All right. So we're gonna just go straight
of
to
course,
it,
it's what it
right?
is.
Yeah, we're gonna go straight to it. I know that there's a lot of questions that our speakers have. I will keep putting in the comments in the comment section. So thank you guys. Thank you for the energy. I love it. Let's keep it going. So yes, you have quite an interesting profile. You know, you work with a firm. You've basically handled a lot of things as regards data compliance for some of these firms, and particularly you understand the startup ecosystem, and you understand that there's a lot of work, a whole lot of work that goes on, in trying to ensure that there's a lot of compliance, and people are not just doing guesswork, right? I'm sure you've been exposed to so many issues and challenges, so we're going to run through them, right? The first thing that comes to my mind when I hear data protection, right? We all hear about it one way or the other, where maybe my information is being used to do something that I did not approve of, and then because of so many scandals that can result from some of those challenges, you've had a lot of regulation. You have the GDPR, the NDPR, and all sorts of that. So we're going to go deep, but I would love to ask you the first question, which is, what exactly, and is there any difference between data privacy, data policy, and if maybe you can answer that question first before we start.
Okay, thank you so much. So, yeah, with regards to privacy policy and privacy notice, yeah, there is a difference between two of them. So, when you're talking about privacy notice, you are talking about an information statement that's what you do with their personal data. So, it's usually published on the website, but not always. So, but when you are talking about privacy policy, strictly speaking, you are talking about an internal information statement that tells the company or the company employees and the staff how they should relate or interact with the personal data of customers they have collected. So that's actually the difference between two of them. I'm quite aware that a whole lot of persons misplace the two. And, oftentimes when you go to websites, you can see a website either naming it privacy policy or another website calling it privacy notice. That is it. But strictly speaking, they are not the same thing. Yeah.
Wow. So I think I love how you've just shattered the table, Sha. Right? Because you go to a lot of websites and it's like everybody's doing the same thing. Like you're saying, okay, this is the day. So you've talked about the fact that a privacy notice is different from a privacy policy. So the things that we usually see on those websites, what are they called? So even though it is named privacy policy, is it a privacy policy? And how does that How is it different from a privacy notice? Maybe you can just give more emphasis because you've answered already, but we would love to know exactly, the difference in itself and how it's applied.
Okay, so yeah, it's when you're talking about the substance, they are not the same. The privacy notice tells customers or clients how you collect their personal data, what you use it for, whether you share it with a third party or not, your legal justification for collecting it, the security measures to protect the personal data. Do you transfer it outside the country or jurisdiction or not? And all of their fundamental rights and all of those. So when you look at NDPR, whether you call it section or article 3.17 of NDPR and 2.5 of NDPR, provided for the information that has to be contained in the privacy notice. So those are the mandatory things you must inform customers whenever you are collecting their personal information. And it includes the name of the company, the purpose for collecting the personal information, the name of the data protection officer, the contacts, maybe email or contact address of the company, the legal justification for collecting the personal information. Are you relying on contract, consent, vital interest, interest, and a whole lot of them? So, what are the security measures you've put in place to ensure that the personal data you've collected are protected? Are you going to transfer it outside Nigeria? What GDPR has said, you must state the principles of data protection. So it is expected that your privacy notice has to contain the principles of data protection and also the rights available to data subjects whenever the personal information or the information provided, the rights available to data subjects, which they exercise anytime their personal data is breached or you do not comply with the information or with the NDPR. So briefly, that's
Thank you
just
for
what
sharing.
privacy notice is. Then when
Oh,
you are
wow.
talking
Okay.
about privacy policy, yeah,
Yes, please
when
go
you're
ahead.
talking about privacy policy, there are quite a whole lot of them. So it depends on the type of policy you want to, uh, the type of policy you have. So the privacy policy can contain, let's say you want to have a policy on how to apply consent, for instance. There ought to be a policy on how to use consent. So the policy has to contain what is the purpose of this policy, who is in charge. Probably usually is going to be data protection officer. So what's the basis upon which the company can rely on consent, or instances where the company can rely on consent. So that is it. Then there could also be an internal privacy statement that contains the legal justification the company is relying, the security architecture, the employee privacy notice, how the personal information that the company has collected, the storage limitation, all of those things, if they have consent form, how the company, is to deploy or instances they can use it. So basically, that's what privacy policy is all about. So it's more like a framework or a guide on how company can interact with personal data they have collected.
I love how you've so I think this is such an interesting and important learning point, right? Because the notice is more or less like, okay, this is what we do, this is how we process, this is, so the truth is that what people have on their website is actually a privacy notice, not necessarily the policy in itself, right? Because the
Privacy.
policy in itself are like internal documents that show different categories of operations and use and how the company deals with it. Although, do you actually think that they both can be merged? So, can you have a privacy policy on a website and a privacy notice?
So
Is it possible?
no, it's not possible. But what I see that is playing out is just people misplacing the terminology, which for me, it's not injurious. Even if you go to court, the court will tell you we have to look at the substance instead of form. So that is it. Now, to make matter worse, the NDPR actually used policy as against notice. So it's still not out of place if a Nigerian company decides to call the privacy notice privacy policy. So what companies or DPO should look out for is whether it contains the necessary information as provided by the NDPR. So that's just what makes it different from privacy policy. So once it contains those information provided in of NDPR and 2.5 of NDPR, then it's whether they term it privacy notice, privacy policy, it's immaterial. It suffices to say that it is a privacy notice. Yes.
Wow. Wow, that's so interesting. For that clarification, and I think that's super important for us. So that we've already started answering the questions, right? So please, guys, keep the comments coming. So you've explained what a privacy notice is. You've explained what a privacy policy is. But now we're talking about data, right? So my first question, basically, what's it? So even though you may have answered it, but it would just be good to recap. So what is data policy, privacy, and why is it important for startups? Why are they important for startups? Why are they important? Because as we work with these startups and we work with these business owners, priorities differ. What is in priority to maybe a startup would be, oh, when are we raising our next funding? Oh, when are we going to go to market? When are we launching our MVP? When are we doing all those things? And you're not paying attention to the legal compliance aspects, which beyond just having your company registered with CAC also has a huge part to do with clients' data, customers' data, how you interact with it, how you use it. So my question in summary is, what's data policy, what's a data privacy, and why is it important for startups? So maybe you can answer the second part, since you've done the first, you answered the first.
Okay, fine. So data policy, data or privacy notice, compliance with data protection. Let me just put it this way. Compliance with data protection is very important for startup. Startup is at the core of tech industry. You know, that means that personal data is very important to them. I will say it's a lifeblood for startup. Now, to underline the importance of data protection, not only to startup but to all other companies, I will use what happened between Marriott and Starwood Hotel in UK, just to underline it. In 2014, Starwood suffered a data breach, which was not known to Marriott by the time Marriott was acquiring Starwood. So around when GDPR was enacted and passed, the DPO, the Data Protection Authority, investigated, and they discovered that Starwood suffered data breach. By then, remember, Marriott has already acquired Starwood. So after that, Marriott was fined 23.8 million US dollars. And now, when you look at that, had it been Marriott was aware that Starwood suffered such breach, probably they wouldn't have even gone on to acquire Marriott Hotel. They wouldn't have engaged or continued with the transaction. Or even if they will continue with the transaction, probably they wouldn't have bought it, at the amount or the price they bought Starwood. So when you look at it, investors are now looking at, is this company data protection compliant? Have they prioritized data protection in their corporate governance before we can come in? Because the regulators are not smiling. You can be fined if cripple the startup, or that can just make them go out of business. Also, startup is very focused at building brand or getting customer trust. So you can't be working towards building a brand and at the same time you are doing something that can actually, bring you down. Because when you suffer data breach, aside the fine or the amount that the regulator is going to, dish out to you, you are going to suffer reputational damage. So that is something huge, and that is why startup has to take it very serious. So they're going to suffer reputational damage if they do not comply with data protection. They're also going to be fined. Now, if a startup is data protection compliant, it could actually attract investors to them. It could actually increase their share value. If a company comes, or let's say a VC wants to acquire it and it sees that you have all the things you are supposed to have in data protection, you can actually have a bragging right that, see, when you buy this company or when you come in, you are very certain that you are not going to have issue with the regulator. So that's that. In summary, that's what data protection compliance does for startup. So yes.
I really agree with this, right? And with everything that happened in 2022, right, with startups falsifying facts, figures, all sorts. The truth is that anybody can wake up one morning and say we are compliant. And if proper due diligence is not carried out, you realize that they'll be like, didn't we have, weren't there people that were supposed to, monitor these things? Right. And this is what brings us back down to the fact that as a growing business, as a startup, you want to ensure that you are dotting all your I's and you're crossing all your T's. To look at the example that you've mentioned, usually when you realize that there is a data breach or there is a lack of knowledge of data policies as it applies to your startup and what you are doing about it, it should be a red flag. But because a lot of people don't know this, they're just like, oh, let's look for the most the shiniest business to fund. And let's be very honest, a lot of due diligence is almost like, how will I put it, is like a rubber stamp on the process, because everybody just wants to make the money and forget that these things take time, right? These things take time, they take effort, and there are things that you have to pay attention to, right? So you are using data, you are selling it, you don't have the proper disclosure or non-disclosure documents before you share this information. You're not doing proper due diligence, you are just rubber stamping. And I think it's something that as professionals and as business owners, we need to insist, right? We need to insist. So it's really, really important for business. And like you said, it makes your business attractive. Like you have an entire policy that guides how you use data, you use client information. Then literally you are literally you have bragging rights, and you can say, look, we are not afraid of anything, that anybody that wants to come and check our books and all. So I think it's very good. So I want you to explain to us some of the laws now that govern the data protection space. So everybody, a lot of people now, they know anybody can just mouth, like you've mentioned, there are some synonyms, or there are some abbreviations or acronyms that you've mentioned here. You've mentioned the GDPR, you've mentioned the NDPR, and the truth is that some people on this call may not know, right? So, can you explain to us what are some of the current regulations we have, maybe domestically for Nigeria, and maybe internationally, that we need to know? At least you don't have to give us details, but what are some of those laws that currently regulate the data protection space, especially as far as startups are concerned? To be great to know that.
Okay. Thank you so much. So in Nigeria, of course, there are quite other laws that you can find, one or two sections talking about data protection or protecting consumer privacy. Even when you look at Constitution Section 37, talks about privacy. However, the main, I don't know whether to call it law or, or regulation, So, but the main law guiding data protection in Nigeria is Nigerian Data Protection Law. It was issued by NITDA. So yeah, as is a subsidiary legislation, so to speak. So, But I'm aware that we have a data protection bill, 2020 data protection bill at the National Assembly, which has been approved by the FEC, Federal Executive Council. Yeah, but for now, NDPR, Nigerian Data Protection Regulation, which was issued in 2029, guides data protection
You mean 2019?
activities in Nigeria. 2019, yes, yes. And then it has implementation framework, that was issued in 2020, November 2020. So it guides, yeah, the data protection, the NDPR and its implementation framework guides processing of personal data in Nigeria. Now, if you leave Nigeria to Europe, you will have GDPR, General Data Protection Regulation. It was issued in 2016 but became effective in 2018. So in US don't have a federal law, so to speak, on data protection, but they have all other laws like HIPAA. Other states are now drafting their own. I'm aware that California drafted California Consumer Protection, which has now been amended by California Privacy Rights Act. Virginia too, they just enacted theirs. So that is it. So basically, what a startup company should look out for is to look at its processing activities, to know those jurisdictions that it has processing activities, or its transactions extend to. That will tell the startup whether it needs to comply with the data protection law of that country or not. So, but if it's just a startup that operates within Nigeria, it's not targeting customers, clients outside Nigeria, of course, it's going to come under NDP. I don't know whether I was able to answer your
Thank
question.
you. Sorry. Yeah, you have. Sorry, I think there's some sort of delay in the feedback, hoping that my internet is not the cause. So thank you. So of course we have the
Okay.
CCPA, HIPPA, and then of course HIPAA, right? And then of course the GDPR for international. So I'm curious, right? So for example, if we know some of these things, that some startups literally start domestically, and then they have to, what's the word, scale. They would scale, they will expand, to foreign jurisdictions. So although yes, if they are operating domestically, sometimes depending on the product, depending on what they are solving, right, especially, many of the times these fintech platforms and all. I will give a typical example. When Binance, came into Nigeria and of course started operating here, they had to comply with our own laws regardless of the fact that they had theirs. So my question is, for startups that are building here in Nigeria and are going to be interfacing with clients, products, businesses that are foreign based, I'm curious, right? Which of the laws will apply, and maybe that could be maybe placed on the foundation of the fact that maybe they ought to have some sort of juristic presence in those countries. I don't know. What do you think? What do you think? Or is it that as long as they are using the app and it's a Nigerian app, then they fall under, or how does it really work in the data space? Because I know how it may work in the trademark or IP space, but we have some experts on the call. I can see Rita here, so maybe she has some thoughts as regards that too. But some of the question is yours. What laws apply, especially if you have an international audience that is beyond the four walls of Nigeria?
Okay, so it depends. Yeah, and this is a general question. It's a usual or general response in data protection. It always depends. So if you look at GDPR, first of all, you have to look at the application of the scope of the law guiding data protection in whatever jurisdiction to know whether it has extraterritorial effect. I want to use GDPR as an instance. So if you are in GDPR, if you are in EU and you are processing personal, sorry, they just took light and Uh, I don't know. I'm already here, so I can't go and come in. So, but I believe you can see me very well. So, if you are in GDPR, I mean, if you are in EU and you are processing personal data, GDPR applies to you. If you are not in EU, for instance, you are in Nigeria and you are targeting EU, people based in EU, because GDPR doesn't even apply only to citizens. Once you are in EU, it applies to you. So, but you are targeting people based in EU, GDPR applies to you. So that is it. Now, if you are in Nigeria and you are a startup company targeting EU-based customers, it doesn't matter whether you are in EU or not. The fact that you are targeting them brings you under the application of GDPR, and you have to comply with GDPR. That's how it applies. Now, if you are in Nigeria, you look at the application of Nigeria, NDPR says it applies to Nigerians who are both in Nigeria and outside Nigeria, and it applies to non-Nigerians who reside in Nigeria. And it also applies to any person carrying out transaction that entails collecting personal data from people residing in Nigeria, Nigerians and non-Nigerians. So when you look at it, if you are a foreigner and you are carrying out a transaction that will lead you into processing personal data of a Nigerian, you come under the application of NDPR. So this is how it applies. And that's why I said it depends. So it's left for the startup to employ a data protection officer or someone that has knowledge in data protection. So the person will look at their processing activities and be able to assemble all the laws that is all that, and then begin to put processes in or frameworks to enable the startup comply with these various laws. So that's how it's
I
done.
love. Thank you for that
I don't know.
explanation. Yeah, yeah. So let me see if I got that clear, right? So in other words, there is a scope of application, right, for the
Exactly.
GDPR. There is a scope of application for the NDPR. And it's important to know that based on what you are doing as a startup, you need to understand the scope, first of all, of the data you're trying to process. Because the truth is, every startup starts with the intention of, think local, go global, right? There are sometimes that before you can even get some particular kind of funding or fundraise or validity or a stamp of approval on your business process, you need to maybe be incorporated in a foreign jurisdiction depending on what your goal is, right? So I asked this question because of conflict of laws, right? So thank you for that answer, but I would just love to also say this, that it's important as your business to check what the law says. So I think you've already explained to us. So for example, the NDPR, basically, if you are processing the Nigerians data, or if a foreigner is processing or is going to be using that, so you have to. Has there so my follow-up question to that is, has there been, and so I see some questions in the comment section. Don't worry, we're going to have so much time for questions. The goal is to finish in 30 minutes so that we can have 30 minutes for question. So I see Real Talk from YouTube has asked a question, so I'll put that up shortly. But so is it possible that you can have multiple laws governing your data policy as a company? Let's say you've gotten the NDPR and the application and the implementation on lockdown. Is it possible that you can have a conflict or a clash of laws, and what happens in that circumstance? Or do you just have more or less like a phrase or a clause or a policy document that says when we are processing data of a foreign national or whatever, their own laws will apply? Or how exactly should it work, from a startup's perspective?
Start by saying this. I don't think whether a conflict of law has a role to play when it comes to data protection. And I will say this because you are looking at whom or who are you collecting, whose personal data are you processing. if you are processing personal data of a Nigerian residing in Nigeria, let me say, for instance, I want to bring up something because NDPR says if the person is residing both in Nigeria and outside Nigeria. Let's say you have personal data of a Nigerian, residing in Nigeria here. You are supposed to look at NDPR, even if you are based in EU. Let's say you are a startup based in EU and you are processing personal data of a Nigerian residing in Nigeria. You must look at what NDPR has said. So, and you must comply with NDPR. Notwithstanding the fact that you also comply with GDPR. And that is why in data protection, you can actually have a whole lot of laws that you must comply or you have to comply with as a startup, depending on the scope of your processing activities. So conflict of law doesn't really come, so to speak. So if GDPR has said you have to provide this and you are collecting personal data under GDPR, you must provide it. That's the fact. The fact that you have complied with Nigerian law as a startup based in Nigeria does not in any way, absolve you from complying with GDPR regulation or requirement. Otherwise, the regulators there will fine you. And if you've also failed to comply with it, they will also fine you. So yes, that's what I.
That's serious. So we've had, so while we're talking about this, we've had quite a couple of questions. So of course, so that we don't rush, definitely Rama, we see your question. Upendo, we see your question. I will answer that. So they're primarily around this issue about, the person is located here. So let me see. So this, I think you've answered this question, but it's by Upendo Haji. Says, what about if the company is operating in Nigeria and the company is a subsidiary of a EU company? The truth is that the person's data you are processing, if they are located in that jurisdiction, you have to comply with the law in that jurisdiction. I don't know if I'm correct, Samuel.
Yes. Even looking at his question, this question that just popped up, what if the company is operating in Nigeria and the company is a subsidiary of EU company? The fact is, from this scenario, that startup must comply with GDPR and then DPR as a matter of fact. Because when you look at
Exactly.
the scope of GDPR, it says, and you are processing, but once you are in the union and you are processing personal, it doesn't matter if you are processing personal data of somebody in South Africa, provided you are in the union, you must comply with GDPR. And then that doesn't absolve the person from complying with South African law, that guides the personal data is processing. That's why data, if you meet DPOs, they will tell you the first thing or one of the most important work they do is that they first of all assemble all the laws that apply to their processing activities and how it applies to their processing activities. So that will give them a clear view on how to approach each compliance. So
Amazing. Yeah, somebody asked a question: does the GDPR still apply in the UK despite Brexit? That's an interesting question.
so you see, it depends. The easiest answer is to tell you no. It depends on the processing activity, just as I said. If you have
Yeah.
a UK company targeting an EU company, I mean EU subjects, so to speak, GDPR will apply. But then if you are just looking at it from the simple way, of course, UK as a country that has detached itself from EU now has its own UK law,
So
guiding
it would
them.
be good. Yeah.
UK GDPR, which is different from GDPR, if that's your question. But if you are looking at whether a UK company can be fined by a data protection authority of EU, yes, of course, depending on the processing activities.
Sure. So, like I said, it's the processing activity. Very interesting. I love how we actually dwelt on this. So now we're going to move. So there's a question that's very important, but it's more or less like taking it a step deeper, which is developing a data policy. right? You've mentioned some things about some of the things that should be contained in a data policy. Somebody asked a question as to a standard compliance metrics or threshold, but we'll address that question after this particular session. But I want you to talk about developing a data policy. What are some of the things to look out for? And then how policies that as regards data security and then storage, maybe reporting procedures, breaches, and all those things. So, what are your thoughts about them? And what should a typical startup have in its data policy that can cater to issues as regards maybe data retention, privacy controls, data breaches, security, transmission, and all those, audits and all those things. So maybe you can just walk us through, maybe based on your experience and some of the documents you may have seen and some of the best business practices. So please, the floor is yours.
Okay, so yeah, there are quite a whole lot of policies you can have as a startup. You know, bring your system or device policy, incident response policy, privacy policy, employee policy, email policy. There are quite a whole lot of them. Automated processing policy, you know, uh, just it depends on the particular policy you want to draft. The NDPR didn't state what has to be contained in other policies aside the privacy notice. So it depends on your processing. For instance, when you are drafting incident response policy, what the policy is all about is the policy tells you how you are going to act or respond when there is, an incident that could lead to such breach. For instance, NDPR says you have to respond or report to the regulator where it will occasion, where the breach we have a high risk. You are to report to the regulator within 72 hours. So the policy tells you who is responsible for this, who is, that's what the policy does. So it depends on each startup and their processing activities. So it's very particular. So that's what the policy does. So the policy will contain, of course, maybe a brief summary about the company, the purpose, and then you begin to, maybe human resources, you are the person that interface with people often. So if somebody sends you a message concerning, okay, I noticed there is a data breach or this happened to this, you are to escalate it to either the departmental head or to this or to data protection officer, and the privacy team is to communicate to the management. There should be a brief meeting. That's what the incident response policy, will talk. And then the privacy, the DPO or the privacy team will assess it to know whether it falls under the circumstances that the NDPR, the regulator said you have to report to the regulator, within so and so time. So if that's the case, they will do it. So it's more like a guideline. That is it. The same thing applies to all other policies. So it's for you to look at it,
That's a whole lot of
look at what the
policies, right?
policy is all about. Yes, there are quite a whole lot. So look at what the policy is all about, and then you approach it that way. So yes, but then
Wow, that's
if you
a
are
lot.
talking about privacy, yeah, if you are talking about privacy notice, if you are talking about privacy notice, I have to stick to privacy notice, so that we know when you're talking about. The NDPR has stated the information that must be contained in the privacy notice. And for the privacy notice to be NDPR compliant, it has to contain all of that information. I know, I know there is a case, the Digital Rights Lawyers Initiative instituted against uh, Ministry of Ministry of Trade, about them not having privacy notice at the Federal High Court, and they won. So I also know that there is a case, a similar case like that by Mr. Babalola. I've forgotten. I looked at, I think the contention was that the privacy notice didn't contain what constitutes consent. Because if you look at Article 2.5 of the NDPR, it says that your privacy notice has more consent. So if you are relying on consent, it has to state what constitutes consent. Are you saying that if somebody clicks I agree, such constitutes consent? Or are you saying if somebody appends his or her signature, it constitutes consent? So if your privacy notice do not contain all of this, then it's not NDPR compliant. So if you are a startup and you have one, you can look for a privacy practitioner who will conduct gap analysis to see the gaps in your privacy notice and be able to fix it. So that's it. Thank you.
Um, wow, amazing. Like, wow. So the truth is that just having or picking templates can't work, because depending
No,
on
no.
where your industry is and what your startup is about, there are some very specific things you can't just. So I have reviewed a lot of I have reviewed a lot of data policy documents, and many times I know exactly where they took that policy from. So you have an e-commerce startup. The next thing they are doing is going to Jumia's website and doing copy and paste and replacing the words. Right? It may be the easiest route, but it's definitely not the best. Right? And there's so in fact that even leads me to the next question. That even leads me to the next question, which is, as an organization, there must be a data compliance department. But the truth is that startups are startups. They are just starting out. Some of them don't even have this internal infrastructure. But the truth is that there are laws that are already governing these things. I'll give a typical example from experience. I know a particular company that, of course, they had spent a ton of money building their MVP and all. They had to go and get the services of a DCPO, right? And for those of you that are watching that don't know the meaning, it's data compliance protection officer, right? There are organizations, there are companies that are primarily dedicated towards helping out with some of these things. And then there are individuals as well, licensed attorneys, corporate commercial lawyers that are able to have those things going on. So someone basically, you've mentioned the fact that all these policies are very important, and depending on how you are running your startup, there are some that are very, very important, and you actually need a DCPO. So I would love to ask, right? We have some questions here by Hosanna, which I think is a good question that can be asked at this point. He says, don't you think the proliferation of policies on data retention, deletion, incident reporting, etc., would affect businesses in terms of compliance efforts and even data management? So it's a lot. So in summaries, there's a lot going on. How do you manage, right? You've given a solution, which is to outsource, get a DCP or have one internally, but how do you think startups should manage this particular thing? Because I can bet you a lot of startups are not complying. I can tell you for a fact.
Okay, sorry, just to be clear, should I respond to that of the DPO or the proliferation of policies? Which one? There are two
You can
questions.
start with the proliferation. You can start with this question, then move to DPU. Sorry.
Uh, okay, so for for policies, the law has said you should have this, and the essence of having this is to help you comply. You know, the DPO needs a framework that he or she must, that should guide he or she to operate. So aside that, the law says you have to have it. So not having it is not complying with the law, which makes you prone to be fined. So I do not even see, rather than saying that it affects your business or it impacts your business negatively, it improves your business brand because you are compliant. All of these things fall under compliances and you just have to do it. There is a reason why they are there. So it's not too much for you to do, depending on your processing activities, so to speak. Now, coming to DPO and startup not having enough money to have one or to have even a privacy team. The truth is, it's not even enough that you have a lawyer who is just a DPO. DPO, I call it privacy team because it involves a college of a whole lot of persons. You need somebody that will be in charge of privacy engineering. You may need even an IT person, somebody, you know, you need a lawyer who has experience in privacy law. So all these guys will work together. And there, because a lawyer may interpret the law, tell you what the law says, but a lawyer may not have the technical ability to implement it. Take, for instance, privacy by design. You need someone with the technical ability to implement it. So why a lawyer is there, giving you the policies, the framework to operate on. The person in charge with privacy engineering, who may even be an IT person, or who may not even be a lawyer, so to speak, you know, will be the person that will implement this or put it into work, you know. So that's it. Now, the when it comes under GDPR for startup, if you don't have, there are threshold before you can have a DPO under GDPR. The NDPR did not provide for it. However, the implementation framework, can I be heard? Can someone hear me? Rosamond is not here. Can I be heard? Okay, maybe I can just continue. So the NDPR didn't provide, you know, or didn't exempt any company from having a DPO. However, the implementation framework, Rosamond, can you hear me? Hello?
Can you hear me, Samuel? Am I clear?
Yes, I can hear you now.
Okay,
Yes, you are
awesome. So
clear.
sorry. I think my network was really, really bad. But yes, I think it's important that you have. Sorry, I had to switch. I think it's very, very important that you have, a very, very clear idea of what the law says. Because when you know what the law says, it becomes very, very easy for you to comply because you already know that, look, this thing is beyond just having somebody who has the technical, or maybe let's just say the book knowledge in a manner of speaking, right? It's important to actually know question. Thank you for the comments. I see them coming. I'll be part. So I think I didn't get the part about the data compliance officer. So what exactly do you suggest in terms of being able to get one on your team, or being able to ensure that you have one who is sound and they actually know what they are doing? What would you suggest, or what would you recommend?
So right now in Nigeria, let me just say the area, and if you can just have one person that can help you comply to an extent, a lawyer can suffice, a non-lawyer can suffice. It depends if you cannot afford to have a college of DPOs or team of privacy practitioners. If you appoint a lawyer, what a lawyer may need to do is to collaborate with the IT department of the startup company, and have these things done. For instance, when I draft privacy policy, I may not know how to publish it, but I can speak with the with the IT department, and they will have it published. The same thing applies to security and all other policies or compliances that the company is expected to undertake under the NDPR. So that is it. You just have to have one. As I was saying, I said NDPR didn't exempt any company from not having, although the implementation framework created a threshold of companies that can have DPO and those that cannot have. But I do not agree. I don't want to go into the jurisprudence of it. I've written an article on it, but I said the implementation framework does not supersede NDPR. It's there to clarify NDPR. And where NDPR has made an express statement or has provided for certain things, the implementation framework cannot deviate from it. So the NDPR says every company. So the implementation framework cannot come and create certain threshold or absolve or remove certain companies from not having a DPO. So that's it. The best thing for a startup company to do is to pick a DPO, because when you look at the cost of not complying from the cost of complying, you would definitely choose. That's my candid advice.
Okay. I think that's a very important question. So the cost of non-compliance can, so I remember some of us here can actually remember, circumstances where you are sent messages, you are sent all sort of texts that this so person did this and were able to do that. So every one of us remember Soko loans that were fined, by the government, I think 10 million naira or so, because of the breaches that happened and they didn't have that. You've even given referrals as to some cases that have been taken to the courts where there were some particular clauses that were even missing for some privacy, some documents, as it were. So I think it's very important to, ensure that compliance is done across board, because really you are going to lose more in the long run, right? You can lose investor confidence, you can lose brand perception, you can lose funding, you can lose opportunities, you can lose goodwill from your clients. You literally, like, it's that serious, right? And I will always say this: don't think that compliance is an unnecessary expense. Think of it as an investment. I think that's the perspective that, as startups and business owners, we should really, really, really think about when we actually, work with or build businesses. I think it's so important. So thank you for sharing. We're almost coming to the 1 hour sprint. So let's go to the last questions that, I would love to definitely ask you. We definitely cannot cover everything today, so you can always slide into Samuel's DM after now if you need more answers, or I'll try to tell him not to bill you guys too much. I'll try. So let's talk about compliance now, right? So we know what the laws are, we know what's required, we know why it's important, we know all these things. But how do we stay up to date with changing regulations? How do we maintain and ensure compliance with? So, in fact, if, for example, we don't even know where to start, where do we start from when it comes to complying? And what are some of the things that we can do to start right away from today?
Yeah. You see, building data governance is not a one-day thing, and it's not a one-off thing. It's a continuous process. And for you to build data governance, you need to have someone or a team that knows something about data protection for them to begin to build data governance. Because there has to be data inventory. They need to know how data comes in and goes out of the company. So from there, they will be able to assemble the jurisdictions or the laws that the company will be subject to. So from there, they will know what the law says and begin to put those things in place. Draft policies. If it's under GDPR, there has to be record of processing activities, policy. There has to be private policy, notice, employee policy. If you are going to rely on consent or any other, particularly consent, you have to ensure there must be an assessment to ensure that it's a valid consent, because it's just not enough to rely on consent. Consent on its own has its own requirement that makes it a valid consent. So all of these things are what the privacy team or DPO has to assess and put in place. In Nigeria, you have to comply with data protection audits. It's necessary because the regulator has said if you suffer data breach, data breach is different from not complying with NDPR generally. If you suffer from data breach, the regulator has to go back to compliance matrix to see before they can determine how much you can be penalized. So it's important that a company operating in Nigeria has to comply with audit, whether or not stakeholders believe that the audit is well done or not, at this point is irrelevant. The law has said, and the regulator has also said, so you have to do it as a matter of fact. So that's what applies. So to be straight or simple, to answer your question in a simple way, to know where to start with regards to data protection for a company, the first thing is for them to have somebody that is knowledgeable in data protection. The person will know how data comes in and goes out of the company. And for the person to do that, there has to be an interaction with the management of the company, the various departmental heads, the people that are in charge of, the people that collect this. Person can have a sort of inventory on how data comes in and goes out of the company. From there, the person will know which jurisdiction will this company fall under when it comes to data protection compliance. So the person will assemble this and begin to put these things in place. So that's the simplest way to do it. And finally, there can't be 100% compliance with data protection law. It's not possible. You can't have 100% assurance that there won't be data breach. So what um, I usually say, or I usually advise companies, you build your data governance to a certain level, then you transfer the remaining risk to an insurance company or a third party company that will bear it on your behalf, because there cannot be 100% data protection. So you should way or the other. So the best way to minimize costs is for you to ensure your data protection compliance with an insurance company. So
Wow, I didn't even know that was a thing. Right. Amazing. So you can act, so once you've been, so I what I hear you say is there has to be a collaboration between the management of the company and then of course maybe the data privacy team or the outsourced professional to be able to, first of all map out what it is, who has access to what kind of data are you processing, what laws are applicable. So I think you've answered a question. So, but I'm going to put it up, right? From YouTube. It says, is there a standard compliance metrics or threshold for startups as regards data policy? I think you've answered that question, but maybe not exactly, but maybe you can answer that question since you already touched on a matrix or something. Yeah.
the problem I have with this question is I don't know to internal policy or privacy notice. So I really don't know the one to answer. But okay, let me just presume it's talking about privacy notice. The law has said, okay, let me presume it's talking about all other policies, whether there is a compliance matrix or threshold for startup. There is no threshold. It depends on your processing activities. You have to have all of these policies, as a matter of fact. If you are relying on legitimate interest, so to speak, there has to be an assessment to show that the your interest or the interest of the company does not override the rights and the freedom of data subjects. As a matter of fact, when you are, I'm aware the NDPR doesn't have legitimate interest as one of his lawful bases. But I'm saying, if at all you have to rely on it, there has to be and when you make this assessment, you have to record it. So therefore, you must have record of processing activities, which is also a policy on its own. You have to have um, what's it called, storage policy and schedule, where the storage policy guides you on how and when you should store, or how long you should store personal data, when you are to destroy it, and how you should destroy it. And the table or the schedule will tell you, okay, the financial data you're collecting, you are going to keep it for 5 years. So after that 5 years, you are going to. So the regulator expect to seize when they come to check or when they come to assess, or if you are conducting data audit and a DPCO comes to conduct data audit, so they expect to see these policies to ensure, at least it gives them, in law we call it a prima facie view that at least you are data protection compliant. and
Yeah.
then they can look at how do you put, I mean, how do you put it into practice. It's one thing to
Yeah.
have it, is another thing to see that you are putting it into practice. So that's it. There is no threshold, you must have it.
Exactly. And I love how you've actually answered that question, because I think the question before this that you answered, you mentioned the fact that how it's important for you to actually have that organogram, right? When you are drafting your policy, you must know there's a process. And of course, you've rightly said you cannot cover everything, so you can ensure the rest. But while you are doing that, you need to ensure that every stakeholder in your organization knows how the data processing policy, whatever it is, works in your startup, right? Because when there is a data breach, which we don't want, when that finally happens, there's going to be an audit, right? And when that audit is done by the regulators, the kind of questions they'll be asking you are going to be based on the law, what the law has already told you to do, whether you did it and you did it the way it was instructed for you to do it. So, for example, the NDPR has regulations as to some of the things to be done. Maybe you're going to have internal trainings with staff or your employees on how data should be managed, and all the way, basically telling you what to do. And if you don't do it, at the end of the day, you're going to end up in some trouble. So, yeah, I think we are down to questions now, but I would love to ask my final question, because I see a lot of comments going on in the comment section. So we have about three questions that we'll just move to, and they are very important questions. But I would like to ask, what are some industry best practices that you recommend for startups to help them with their data compliance? What are the best practices that they should kick off now? I know it's almost similar to the first question, but industry best practices that you see, that that are quite important for startups, for them to be able to become data compliant.
Have a DPO, have privacy notice, have internal policies, have good security architecture, so you can comply with ISO 27001. That's I'm not an expert in cybersecurity, but of course, ISO 27001 gives you certain controls when it comes to security. So, anti-firewall, anti-firewall, antivirus policy, email policy, and all of the encryption. So, all of these things, you have to ensure that it's well in place to ensure that the data you are collecting does not, escape, or you do not disclose it here. Then, if you have a third party, you have to have third party data processing agreement before you can, enable them to share. The essence of the policy is, one, it helps you comply with the law because the law says you have to have it. Secondly, the third party processor, it limits or it states the extent and limit of the third party's power. So that when the third party exceeds the power or the instruction given in the data processing agreement, it becomes the data controller with regards to that further or subsequent processing activity. So, and to an extent, it absolves you from certain liability. It's possible for for a data protection authority to approach you, or even for data subject to approach you, who was who collected the personal data. But the good thing is you will be able to claim back from the third party, because the third party has exceeded the instruction that you have given. And of course, there are certain clauses that has to be in the data processing agreement. So you need to have these things in place. And you have to look at, are you transferring data to foreign countries? If you are doing that, you have to follow the law, what the law has said. In Nigeria here, we have a whole lot of conflicting, it's not very clear, so to speak. But the most important thing is, if you are transferring data outside jurisdiction, of course, you have to know whether you are doing that, and you need someone that has data protection law, to be able to tell you whether you're actually transferring data, outside jurisdiction. So the company, you have to file certain information with the Nigerian Data Protection Authority or Bureau, stating the company, the type of personal data you are transferring, all of those things. You have to lodge it. Normally in EU, it depends. If the company, there has to be an assessment, transfer impact assessment, and all of those. If the company doesn't have adequate data protection law, as stated, you're supposed to use either standard contractual clause, depending on the circumstances, or binding corporate rule, and some other mechanism in place. So that's if you are talking about the international best practice. But here in Nigeria, it's neither there or here. It's neither here or there. So that is it. And all other things,
Yeah,
sure.
okay. Wow, that's a handful. So it just goes to show how important it is, and it's very interesting that it's not only startups that this affects. This affects any business that processes data, company data, client data, and it's very interesting how we need to be aware of these regulations. So you've said a lot, right? We can speak for 1 more hour on this, but I want to leave the floor open for people to ask questions. For me, I think one of the things that you've really, really paid or made attention to is you cannot do without those regulations, right? You need to know what they are. And then, of course, when you are dealing with third parties, because sometimes the data breach doesn't happen because of you, it happens because of the person you are doing the business with, right? So there has to be, third party agreements that even protect you as a business, and it's super important, right? You don't want to mess up or make mistakes and end up, taking the fall for things that were not your fault. So very important. So we have two very interesting questions here, and I think with that we may bring to a close because it's quite a lot. But I really love the conversations. I love the conversations here. So I'm going to be asking the question from. Let me see. I have one question here. So Rama says, can you please explain the concept of relying on consent and legitimate interest? So she wants to understand those concepts as far as yeah.
Okay, so the law says before you can process, in fact, the law says you must not process personal data unless there is a lawful purpose for doing so. And under NDPR, it's listed some lawful purpose you can rely on to process personal data. One of which is consent. So, and just as I said, it's you don't just have to rely on consent just for the sake of relying on. Before you can rely on consent, the law says for consent to be a valid consent, it must be freely given. So it must be in a situation where the data subject has to whether I have to consent or not. And if he or she says he's not consenting, you know, there shouldn't be a negative impact for his or her not consenting to the processing activities. You know, it has to be informed. So you need to inform the data subject what you are using the data, what you are using the data for, whether you are transferring it outside Nigeria or outside jurisdiction or not, the security measures, just the information that's usually contained in the privacy notice. Then it's need to be clear. Doesn't have to be the consent doesn't have to be ambiguous. So you don't have to merge consent with other thing. Maybe in your website you're having consent, you're telling the person to consent for processing of personal data, consent for terms and condition. So once the person clicks the whatever, either ticks the box, then the person has consented to all of these things at once. So the consent has to be clear, it has to be separate from all other consent that you require for other things. Then, very important, the data subject must have right to withdraw that consent at any point in time. Very, very important. So you must have right to withdraw the consent at any point in time. So if these four requirements are not present, is not a valid consent. And I'll give you an instance. A company cannot rely on consent to process certain uh, employee data. The reason is this: the law has recognized that there is an imbalanced power. Of course, there are instances where somebody can rely on other lawful, but a company cannot rely on consent to process an employee personal data. The law recognizes that so you won't be able to say, no, I don't want to consent to this because there is fear you may lose your job. So the law has come to intervene on your behalf to say that company cannot. But I'm very much aware that a whole lot of companies rely on consent to process. But these are instances where you cannot rely on consent because it impinges on one of the criteria of, of a valid consent, which is that it must be freely given. Secondly, the fact that the person can withdraw that consent at any point in time. It means that if I give you consent today, I can come tomorrow and say, see, I'm not giving again. I've taken my consent back. So stop processing. So will you be able to do it as an employee? So it's not possible. So that gives you, it tells you that consent is not the best lawful basis for this processing activity. So now, legitimate interest, for instance, in GDPR, is one of the lawful basis you can rely to process personal data. The NDPR omitted it. However, I'm one of those that believes that it's indirectly provided for it because when you go to audit templates, there is a place it's stated that the company has to indicate whether they're relying on um, was legitimate interest or not. Even in the Article 3.1.7, it stated that a company has to state the legitimate purpose or interest they are pursuing. So when you look at that clearly, somebody can actually argue that the NDPR provided for consent. The only difference is it didn't provide it under the section where it's provided for lawful reasons. But I'm very aware that you interpret the provisions of statutes are not interpreted in isolation. So that's it. So, but then that's about that. The 2022 provision for legitimate interest. So, but before you can rely on legitimate interest, you have to undergo certain things because the legitimate interest is sort of gives power to the or control, a sort of control, not power, a sort of control to the company. Company says you can rely on your own legitimate interest to process personal data. So the company can say, okay, for my business interest, I am processing. I'm not, of course, I'm not. I'm just giving an instance. A company can say, for my business interest, I am processing this personal data, or to ensure that my company keeps, going on as a going concern and processing this personal data. However, the law decided to introduce certain restriction because if it allows company, to go on that way, then there may be an abuse, or misuse of personal data. So the law said the legitimate interest has to pass three tests. The test of necessity: is the processing activity necessary? There is no legal interpretation in Nigeria, neither has the regulator issued any interpretation. But when you look at EU, it says for processing activity to be necessary, it means that there is no alternative means you can use to achieve that purpose without using that particular means you want to rely on. So the proportionality, we are going to look at the processing activity and the harm it may occasion, to the data subject. So the necessity and proportionality test, they go together and they are an offshoot of data minimization, or so to speak. Then you have to look at the third test, which is the balancing test. You have to look at the end of the day, does the processing activity override the interest of the data subject, or does the interest or the right of freedom of data subject override activity? So the last test will determine whether you will rely on legitimate interest or not. So in a situation where the right and freedom of data subject overrides the processing activity or whatever thing you want to achieve, you don't have to rely on legitimate interest. And that is why I talked about legitimate interest. So before you can rely, there has to be an assessment of legitimate interest to know whether you meet with all these requirements. So that's
Wow, that this is intense, guys. Wow, wow. Thank you very much for that very detailed answer. And I think for everyone that is watching, I think this is something that you should watch again, right? And maybe this time with the NDPR beside you, because it's such a very enlightening response you've given. Thank you so much, Samuel. We have two more questions, and after that, we'll have to wrap it up. I'm hoping to finish in 10 minutes. But we have an interesting question from Tamuno Tekena. Yeah. So yes, like I said, the floor is open for questions. Said so. If this question would be allowed, Rosamond, then please let me ask: at what point would a startup insure its data breach risk with an insurance company? Is it at the point of drafting the policy, when the business is yet to commence, or during the subsistence of the business? So that's a question. I think that's an easy question, maybe answer.
okay during the subsistence. You see, it depends on what the company wants. It's not a requirement of the law that you have to insure. I'm just saying it's a legal. I'm just saying that okay, for the fact that you cannot achieve 100% compliance with the law, for all of that, maybe let's say we are using range. You build your data governance up to 70 or 80% or 90%. The remaining percent, just transfer it to a third party that will bear the liability when you know regulator comes coming or anything happens. So it private drafting privacy policies is one of the things you are supposed to do. Is That's not all about compliance. We're even talking about privacy by design. Privacy has to start at the onset when you are building the product. Privacy by design, you need to consider privacy at that point in time. And the privacy has to be, you have to set it by default. By default, you need to comply. The product has to be data protection compliant by default. So it's at this point that you will begin to build your data protection compliance and all of that. So the company can, these are things that the board can consider after the company has started. These are things the company can consider before they start. These are things maybe the promoters, it depends on how the company wants it. The company can do it before it commences business. They can do it after it commences business. So it depends on their risk appetite. So they can even decide not to do it at all, and say, okay, no problem. Whenever it comes, we'll see how to settle it or take care of it. So that's just it.
Amazing. Thank you for that very interesting and direct answer. I hope Tamnu that answers your question. So we have one last question, and after this, we'll just wrap up with general comments and of course feedback. Thank you so much for those of you that are still live till now. Thank you so much. So we have this last question from Hosanna, who says, "What are some potential areas for future development or refinement of the NDPR and GDPR in response to changing technology, societal trends, and other factors?" So this is like a wrap-up question in the manner of speaking. So yeah.
This is no long. This question is not related to startup, but we're already arguing jurisprudence here. So in honest, you are asking me to state some of the lapses in NDPR. Of course, there are quite a whole lot of that, which the 2022 bill has been able to close all. I'll not go into that because it's really wide. Just as I said, the issue relating to legitimate interest, it's neither here or there, and there are a whole lot of arguments. And there are some processing activities the company cannot undertake without relying on legitimate interest. So that on its own is more like a stumbling block to commercial activities. So other things in NDPR, like international transfer of data, that the provision is not clear enough. The right of data subjects are not clearly spelled out in the NDP. There are a whole lot of faults which the regulation, the bill, take care of, not everything. Then in terms of future development, we can begin to begin to consider about AI and the incidence of AI, how it will affect or impact people's privacy rights. Talking about discrimination from the angle of AI, it also relates to data protection because the essence of data protection is to protect you. You shouldn't be discriminated based on certain things. So we also need to look towards that side, AI, machine learning. Yeah. So
Exactly.
is
Thank
that's
you. And I think you thank you. I think it's very important that you've mentioned this, especially with a lot of innovation is coming on. And it's such an interesting question, right? Where at what point do you draw the line between what belongs to you and what can be used on your behalf, right? You have AI drawing tools, you have AI typing tools, and the truth is that, so for a typical example, right? I was listening in a conversation between stakeholders in the corporate governance space, and we're talking about what's the difference, what is the thin line when you have generated AI, artificially generated images or content from people who never gave their consent, or people who have passed on and their faces are being used for designs, or where do we draw the line, right? And these are things that we really need to start thinking about as privacy practitioners, as legal practitioners. There are things that you need to start raising. There are things you start researching on, things you should start, proposing to the policymakers out there, because we can't be left behind, right? You have a lot of countries that are now trying to, build or create regulations around these novel changes, and we cannot be left behind. It's not just about, can you give me your name and your password and all that, right? That's part of it. But where we are going, globally, is a fact that the lines are going to get more blurred. You are having things like deep fake, where you can literally have somebody come on that looks like me, saying things and speaking with my mannerism, with my voice, right, on my behalf without my consent. So where do you draw the line? So I think these are things that we have to start thinking about. There are questions that we need to start asking. There are things that, as business owners, as practitioners, we need to start raising these questions and ensuring that, we are protected enough, and raising this concern so that, we don't end up into, we don't start or cause casualties that are the ripple effect of, non-compliance and all that. So thank you for that interesting question. So we have 3 minutes to go, right? I will, for those of us that are still here, I want you to just put in the comment box how this session has been, and throw some flowers in Samuel's direction, because I would confess he has done such an amazing work, an amazing, amazing, amazing work today. Thank you so much, Samuel. I would love to know what your final thoughts are. And what are some of the things that you would want a startup listening in, or that will have the opportunity to listen to this conversation right now, even at the point where they'll be watching? What would you want to leave them with? And your final thoughts before we go. Thank you.
um okay. Thank you so much. I once read a publication that said or that reported that 20% of the world's economy is digital, and the remaining 80% runs on digital platform. We are in a tech driven or even uh, digital economy, and where the value attached to personal data has increased. So data protection, as a matter of fact, has become a top priority when you are considering corporate governance issues, because it's something that can make a company to go down, something that can increase the value of a company at the same time. So now in Nigeria, it's a novel area or a novel practice. But the advantage of it is trying to flow with the beat right now and not waiting till when the whole thing is set. If you start now to build, now that the regulator is not very serious about it, startups, companies should begin to cultivate the culture of building data protection. Start small. So so that by the time the stage is set, you won't have yourself to blame, or you won't begin to run around, where do I start and all of that. And by then the regulator will not be able to tamper justice with mercy, or to say, okay, we know that this thing is still coming into Africa, so we expect companies to be struggling, because they have given companies actually a long period of time to understand the concept and how to comply with these things. So my last, or yeah, my parting words to startups is that you have to start now to comply. You don't have to wait later. The whatever amount that companies have to spend complying will never be commensurate with the amount you are going to pay by the time you are fine. So it's now companies should begin to make separate budgets for data protection whenever they are considering budget, whatever budget they want to use and run the company. So thank you. And thank you everybody that came around here
Amazing.
to listen to what you have to say.
Amazing. Thank you, Samuel. Thank you. If there's one word I got from that, is that no expense is too much to start and do the right thing. Because what you will get at the end, if you don't do the right thing, will be costlier than if you started right in the first place. So thank you very much, Samuel. We have very, very good comments for you. So Lollywood says, thank you, Samuel, for such an insightful teaching. Adaobi says it's been an enlightening session. Thank you very much, Adaobi. Really appreciate your comments. Thank you, Jagade David. We are very, very grateful. So with this, we've come to the end of the fifth edition of the Startup Compliance series. I want to say a very big thank you to our amazing guest who has done more than justice to this particular topic. I'm very excited. I'm going to go back, watch over again, and I know that it will be so much to learn. Please, as business owners, make sure that you are taking the insights. As practitioners, as legal advisors, take this information that you've gotten today and share it with your team, share it with your divisional head, share it with your department, share it with your firm, and I'm pretty sure that you are definitely going to add value, because these are very, very relevant issues that you have to address. So with this, I want to say very good evening and good night to everyone. I wish us a very pleasant weekend. Have an amazing one, and bye for now. Bye, Samuel. Have an amazing weekend too. Bye.